Hello there, I'm Paul Brown. I'm a senior solicitor with Burnett Solicitors based in the Newcastle office. I'm here today to provide a presentation alongside a colleague, Dr. Julian Harris, on the Guide to Best Practice Rehabilitation and the Medical Legal Process, which is in association with Remote Rehab, who have marketed this presentation today. Go through the overview and aims for the presentation today. The webinar seek to cover the rehabilitation needs being addressed in the NHS. Secondly, whether the British Society Rehabilitation Medicine Guide to Interface of Rehabilitation and Medical Legal Process. We'll be covering the Rehabilitation Code, also the Serious Injury Code, and also the importance of interim payments and access to early specialist legal advice. And then Dr. Julian Harris will be covering the areas in terms of access to medical treatment in major trauma centres and also access to rehabilitation prescriptions and specialist rehabilitation prescriptions. So starting off, in terms of the rehabilitation definition, according to the BSRM is a process of assessment, treatment and management with ongoing evaluation by which the individual and of course their families and carers are supported to achieve their maximum potential for physical, cognitive, social and psychological function, participation in society and quality of living. So specialist rehabilitation is the total active care of patients with complex disabilities by a multidisciplinary team who have undergone recognised specialist training rehabilitation, led and or supported by consultants trained and accredited in rehabilitation medicine. So there's evidence normally taken, there's obviously now a substantial body of trial-based evidence and other research to support both the effectiveness and cost-effectiveness of the specialist rehabilitation. And despite the longer length of stay, the cost of providing early specialist rehabilitation for patients with complex needs is rapidly offset by longer-term savings in the cost of community care and making the highly cost-efficient intervention. So the importance of rehabilitation in terms of the medical legal process is clearly shown, and something that obviously as lawyers need to engage with. So just looking at the National Clinical Order for Specialist Rehabilitation, so the NCASRE report, which was published back in April 2019, this showed for a group of 1,381 individuals assessed as requiring specialist rehabilitation, only 40% actually received it. And the report went on to establish that 94% becoming more independent in activities of daily living, which in turn reduced the costs of ongoing care by an average of £536 per week. Clearly, there are clear indications following on from this report that there is a clear need for rehabilitation, access to rehabilitation, and unfortunately not all of that is available on the NHS at the present moment in time. And therefore this shows that there's clearly a need for access to rehabilitation for patients, and if the medical legal process can provide additional support, then clearly we need to try and address that. So taking some statistics in terms of acquired brain injury, an area that I'm particularly involved with the UK Acquired Brain Injury Forum. There's one of three of us will sustain an acquired brain injury in our lifetime. There's approximately 1.3 million people living with a traumatic brain injury in the country at the moment. And this reference to £15 billion. This £15 billion of savings that would be made in terms of early access to specialist rehabilitation services if that service was provided. And that's in terms of obviously lost work contributions and obviously in terms of health and social care in particular, the care requirements for these individuals in the longer term if this specialist rehabilitation isn't provided. Also, just to make the point that in terms of children in particular, there is also some study, obviously the report from the Children's Commission back in October 2012 indicated that in terms of traumatic brain injury, as opposed to other conditions such as autism, ADHD and learning disabilities, you can see that the percentages of those children with a traumatic brain injury dwarf these figures. And indeed, that does show the size of potentially the issue in terms of access to rehabilitation, not just for adults, but also for children as well. So taking that forward, in terms of the British Society of Rehabilitation Medicine Guide, this was published back in 2006. This is a guide to best practice at the interface between rehabilitation and the medical legal process. And this was developed with input from the British Society of Rehabilitation Medicine, Royal College of Physicians, the Association of Personal Injury Lawyers, APL, and the Forum of Insurance Lawyers, FOIL. And this was sought to address the confusion often caused by the process of implementing medical legal recommendations in further rehabilitation in the medical legal process. And this provides some guidance and some best practice in terms of an interface between the NHS rehabilitation services and the medical legal process to try and make sure that the patient and their outcomes are optimised wherever possible. This took into account that both solicitors and insurers must be free to choose how they conduct litigation, taking into account client privilege and consent. But also, it really was a means of trying to ensure that those appropriate communication takes place between solicitors and those working in NHS treating teams to avoid placing additional burdens on the NHS and hopefully improve the outcomes, as I said, in terms of patients and importantly, their quality of life. So just going through the guidance, the first point was in terms of the guidance during NHS treatment. So whilst the patient is undergoing ongoing NHS treatment, it was important that the recommendations made by any party involved in a compensation process, so with a litigation or by a medical or other experts, should be referred back to the NHS specialist for consideration. They should be given that information to assist with their ongoing treatment through the NHS. Where additional alternative treatment is proposed, obviously myself as a claimant solicitor should inform the NHS specialist who would advise as to whether such additional alternative treatment is likely to be reasonable, beneficial, or in the best interests of the claimant, whether it might be available on the NHS, as it often is, and if so, in what timescale that will be provided. Advice should also be sought regarding the type and location of the facility to be used for delivery of that additional treatment, and the response of the NHS specialist should then be communicated to the claimant as the patient so that they can make an informed decision. And subject to the claimant's consent, that decision and the information provided to the claimant would then be communicated to the insurer or compensator with a view to seeking an interim payment of damages to fund that treatment privately wherever possible. Funding also may be secured through the compensation process to provide a range of support services for the claimant, and this will often include personal care, aids and equipment, transport and housing. Obviously that is subject to liability issues, and it's not always straightforward in terms of a legal claim as to whether or not funding will be provided at the outset. But clearly, as a claimant lawyer, my job is to try and do that and make sure that those interim payments are put in place. It is good practice for the claimant solicitor, and something that certainly I continue to practice, is to keep the NHS team informed about any plan provision in relation to such issues. So that would include attending any MDT meetings wherever possible to make sure that there is that interface between the two processes. And also in terms of discharge planning and ongoing health and social care assessments undertaken through the NHS and statutory services, that should also be copied to us as the claimant solicitor wherever possible, and subject to the claimant's consent, disclosed to the defendant's insuring compensator or solicitor. And that should also include, as I've noted in the slides, the rehabilitation prescription, which we'll come on to reference later on. So wherever a decision is made to seek a separate assessment of rehabilitation needs, whether that's under the Rehabilitation Code, which I'll come on to deal with in a second, with a view to considering additional alternative rehabilitation treatment, such decisions should only be made after proper full consultation with the NHS specialist. And again, it is important, particularly if ongoing treatment is being provided at a facility. If the claimant is then engaged in with a private clinical case manager, as often is the case, if early interim payments are provided, and as they often they are through the legal process, then the clinical case manager should then consult with the NHS rehabilitation specialist, and if appropriate, obviously with ourselves as solicitor, claimant solicitor, and subject to the claimant's consent, the defendant insurer, to make sure that there's an agreement going forward in terms of recommendations, in terms of ongoing treatment. But again, that should be, the claimant should be informed, and the patient should be informed of that process and to what extent this NHS team has contributed to those recommendations. There's also duties of confidentiality which do exist in relation to the claimant's treatment at all times, and it must be respected so to ensure that information concerning the claimant is not disclosed to third parties without the claimant's written consent. So the patient must consent to their information being provided. If the claimant agrees to undergo private rehabilitation treatment with the support and approval of the NHS specialist and rehabilitation team, then the NHS specialist should retain overall clinical responsibility until such time as the claimant is discharged from NHS treatment. Again, the ongoing care of that patient is paramount, and obviously the NHS specialist who has overall clinical responsibility will continue to have that responsibility. It would be normal practice for the clinical responsibility to transfer, however, to an appropriately qualified medical practitioner at the private facility once transfer is complete. And if therapy or the treatment is provided to the claimant in the community, then often the NHS specialist may wish to review the benefit of such treatment from time to time. The NHS specialist may wish to give advice and guidance on such private rehabilitation treatment in the future, in conjunction with the claimant's GP and clinicians involved in delivery of private treatment. But again, in terms of overall clinical responsibility, once that discharge takes place, then often a consultant will take over that responsibility overall. And in the circumstances where the claimant wishes to receive private rehabilitation treatment outside of the NHS, and the NHS specialist or rehabilitation team disagree with the proposal being made, then the ultimate decision should rest with the patient, the claimant themselves, obviously subject to the provisions of the Mental Capacity Act, as often the claimants that we deal with do have capacity issues in terms of treatment, but obviously under the Mental Capacity Act, obviously they would be assessed as having capacity unless they've been medically assessed otherwise. But in terms of my job as a claimant solicitor, that would be to encourage the claimant to carefully consider the advice received from the NHS specialist and rehabilitation team. And then if there was a conflict that did arise, it would be desirable that the NHS specialist should be able to consult with the private specialist directly in order that, if possible, a compromise or agreement can be reached that is in the best interest of the claimant. So again, collaboration between the NHS and the private provision is really important for the purposes of making sure that the benefits of the claimants and their outcomes are optimised. So moving on to when a claimant is discharged from NHS service. So when a claimant has been discharged from treatment under the NHS and further treatment is recommended by any expert instructed in the medical legal process, it is good practice for a solicitor to ensure that the medically qualified medical practitioner or the appropriately qualified therapist or nurse is prepared to accept clinical responsibility, so ensure that there is somebody taking over that clinical responsibility for management of the treatment programs. And then again, we may need to get additional advice from the NHS specialist, the rehabilitation team, or indeed the GP in terms of ongoing treatment thereafter. If the claimant requests his solicitor to arrange private rehabilitation treatment, then again, the solicitor should satisfy themselves that such treatment will be provided under care control of a properly qualified medical practitioner, therapist, or nurse. And it's clearly inappropriate for me as a solicitor or any other non-clinically qualified individual to take responsibility for management of such treatment. And again, just to make the point in terms of records, in the course of claimant's private rehabilitation treatment, these are subject to the normal rules with regards to confidentiality and should only be disclosed to third parties with the claimant's written consent. In terms of medical legal assessments, it's important to re-emphasise that myself as a solicitor has a duty to act in the best interest of the claimant at all times. And obviously we have to assist the claimant to optimise the rehabilitation potential and thus improve quality of life. But in terms of the party involved in the compensation process and receiving expert comment, obviously that may well assist the NHS specialist or rehabilitation team with the provision of treatment. And then obviously subject to the consent of the claimant, we would often disclose that evidence to the NHS teams, and thereafter that correspondence should also form part of the claimant's medical records. It should be available for proper disclosure in terms of that. It is important, however, to mention in terms of an initial needs assessment, however, that those documents are normally provided pursuant to the Rehabilitation Code. And unless the parties both agree that that document is disclosable, then it wouldn't normally form part of the claimant's medical records. And obviously, in terms of a general obligation, it is subjected to the overriding duty of myself as a solicitor, acting the claimant to advise about legal rights in pursuing the compensation claim and act in accordance with the claimant's instructions. So an example is that obviously legal privilege normally applies to a report until it is disclosed. And it's often the case that because of the complexity of these cases, that often we will discuss many of the medical reports in conference, in draft, before they are formally then disclosed later on. So there can be some delay between getting the actual report in draft and then being in a position to disclose it to the obviously teams that are providing treatment. And it's important to have that distinction. In appropriate cases, the parties may also ask a medical legal expert to contact the relevant NHS specialist. And I have had a number of occasions where this has happened in the cases I've dealt with, in order to discuss recommendations and nature of treatment. And again, it is important that particularly when there are competing areas of disciplines, that the experts do speak to one another, whether that is in terms of medical legal assessment, or whether that's obviously NHS, and obviously that communication is an important process part of the process. A note of any such communication would normally be retained on the treatment record, so that is again something to be aware of. And again, it's good practice for the solicitor or medical legal expert to inform the NHS rehabilitation team of any medical legal assessments. For example, in terms of a neuropsychological assessment, obviously you would want to make sure that there is a 6-month gap between neuropsychological assessments. And obviously, if a full assessment or part assessment in terms of some of the neuropsychological tests or neuropsychometric testing is taken place, then it's important that the therapy teams are aware of that, because that could obviously have an impact on testing, for example. But obviously that also applies to other assessments as well. In terms of the normal reference to medical legal experts, they wouldn't normally play an active part in clinical treatment. There are, however, some times when, if the area in question is quite a specialist area, and there is a lack of particular specialisms particular experts in that area, then I have on occasion asked that medical legal expert to have some further part to play in terms of the clinical treatment. An example is that there's a specialist urologist that I regularly use in terms of medical legal specialisms, and it can be very difficult to get a urologist who is expert in a spinal injury or brain injury locally. then I may ask them to provide some assistance in terms of the ongoing treatment in that regard going forwards. But again, that's fairly rare in my experience. In terms of whether a medical legal expert or clinical specialist, either in the NHS or the private sector, should make a recommendation for rehabilitation services to be provided, then obviously that particular rehabilitation facility or provider or agency must declare any interest or direct, indirect or financial interest in that facility, provider or agency. And again, that's an important part of the independent nature of the medical legal process, and certainly I would be asking any medical legal experts to obviously advise of any such interests. And again, one of the reasons why we have various consultations and conferences with experts is to test that evidence and make sure that it's fully independent. So moving on in terms of NHS assessments. So again, those assessments carried out by the NHS rehabilitation team as part of that NHS rehabilitation process will often inform and help the medical legal experts in preparing their reports. I've given examples of discharge summaries and rehabilitation prescriptions. These are really important documents and need to be provided to the experts alongside all of the other investigations that are carried out in terms of the NHS. And again, one of the difficulties that we can often have in terms of medical legal work is that we need to have a full set of medical records, which are often available from various different trusts whilst the claimant is undergoing treatment. And that can often be a difficult jigsaw to pull together. Where the claimant is continuing to undergo rehabilitation in the care of the NHS rehabilitation specialist, is often very helpful for the parties in developing an understanding of the clinical issues and the claimant's rehabilitation needs for the NHS rehabilitation specialist to be instructed to prepare a preliminary assessment report. And again, sometimes that might play a role in terms of providing a summary of what that the treatment has been to that point. Whenever an NHS rehabilitation specialist is requested by ourselves as claimant solicitors or by the parties jointly to produce a report, that would normally be being prepared for the purpose of treatment anyway, but such a report would not form part of the claimant's medical records, but would be subject to the rules of legal professional privilege. And again, there are rare occasions when that will happen, but normally it would be an independent report that would be obtaining. So moving on to discuss the Rehabilitation Code. Now, the Rehabilitation Code is a code that has been established between claimant lawyer organisations and also the insurer organisations themselves. And we as solicitors sign up to the Rehabilitation Code to ensure that there is a joint duty to consider rehabilitation needs of an injured claimant. And the Rehabilitation Code was set up to try and ensure that in terms of the personal injury claims process, this is obviously designed to restore the individual as much as possible to the position that they were before the accident. The code therefore provides a framework for the claimant solicitor and the compensator, so that's the defendant, insurer, and indeed the solicitor, to work together to ensure that the claimant's health, quality of life, independence, and ability to work are restored before or simultaneously with the process of assessing compensation. So again, the Rehabilitation Code is a tool to try and ensure that rehabilitation is provided at an earlier possible stage. Where there's no agreement on liability, and again, that can often be some time before liability is fully established, parties may still agree to use the Rehabilitation Code. And there's been many cases that I've been involved with where insurers have agreed to make without prejudice interim payments to pay for items, whether that's for items of equipment, treatment, support, case management, or in some occasions accommodation. All of these things that need to be addressed. But the health and economic benefits of proceeding with the rehabilitation at an early stage, regardless of an agreement on liability, may be especially strong in serious cases. So there is often a financial benefit to the compensators themselves by providing some access to rehabilitation at an early stage. And again, that's sometimes beneficial for them also. Although the Rehabilitation Code deals mainly with the provision for an immediate needs assessment, and again, that's an independent immediate need assessment. It's often prepared by case managers in particular. It encourages all parties, both claimant and defendant, to adopt a collaborative approach right up until the legal case is concluded. So again, that collaborative approach between claimant and defendant can often benefit the claimant a lot in terms of access to rehabilitation. In terms of the Serious Injury Guide, this is a guide that was established to deal with claims of on a full liability basis of £250,000 or above in terms of valuation of compensation. And that's likely to involve a claim for an element of future continuing loss, such as loss of earnings, care provision, case management, etc. And that encourages, again, a positive collaborative behaviour from both sides and work parallel with the civil procedure rules. This guide does include reference to the need for early notification to defence insurers so that they are fully aware of what the claim that they are meeting. Case planning with regular route planning meetings. So I will often have regular route planning meetings with the defendant insurer and solicitor to discuss the case, confirm how things are progressing in terms of rehabilitation, but also make sure that they are fully up to speed as to how things are moving forward with the litigation itself. Liability matters often resolved where possible within 6 months of notification, but again, that liability discussions can go on for much longer than that, depending on how complex the arguments are. A commitment by the defendants to an early interim payment of disbursements. Again, in terms of disbursements, that references things like medical reports and other expenses that are part of the claim as well. And in terms of the discussion at the earliest opportunity by all parties to consider effective rehabilitation, again, that is enshrined in the Serious Injury Code to ensure that there would be an appointment, where possible, of an independent clinical case manager which would normally be instructed by the claimant to address the clinical need for rehabilitation. There are some occasions where a case manager would be appointed on a joint basis, but I have to say that they are fairly rare and would normally only be in cases where there are severe liability issues, whereby there might be some benefit to the claimant to have a jointly instructed case manager on the basis of the Rehabilitation Code, because there would be 100% funding for that. Defendants will often make early and continuing interim payments as part of the process, and again, in terms of what we reference as Part 36 or call-the-bank offers, again, that's discouraged in this process in terms of early offers being made as a way of trying to ensure that there's this collaborative approach and that there's no tactics being played unduly. Obviously, there must be a way forward in terms of negotiations, in terms of trying for settlement purposes, but again, by making these offers, this can sometimes be counterproductive. And again, there must be a commitment by all parties to obtain and disclose promptly all relevant documents. And again, that will include all the medical records and information. So that's a quick run through of the BSRM code, the information relating to the Serious Injury Code and Rehabilitation Code. My contact details have just popped up on the screen. If you do have any issues or wish to discuss any patients confidentially, I'm more than happy to have discussions with individuals. But I'll pass you over to Dr. Julian Harris, who's going to take us through the separate major trauma centres and the rehabilitation prescriptions in terms of what's available on the NHS at present. I'll hand it over to Julian.
Thank you, Paul. I'll begin by just introducing myself in the next couple of slides and some basic principles. I'm going to take a very clinical approach to some of what I'm sharing with you today, bearing in mind that Paul's covered the legal aspects of things and I'm not a lawyer, but also because I appreciate that about 2/3 of the way into this presentation now, you're probably getting a bit numb around the haunches, your coffee is just starting to wear off, and the temptations to wander off and do something more interesting are looming. So I'll try to pepper my comments with sometimes amusing and hopefully always relevant anecdotes. So to begin with, if I can just have a look at the first slide, I'll tell you a bit about myself and why it's important for you to listen to me and not go off and put the kettle on. I was involved in the establishment of the major trauma centres at King's College Hospital about 10 years ago in a very active way, having moved back to the UK from Canada in 2008. There's a bit of relevance to that too, because having trained in North America, I completed my board exams in rehabilitation medicine, physical medicine and rehab. And that makes me an international rehab consultant, so I work all over the world. And some of the lessons I brought back from Canada were those that were also being learned at that time in Afghanistan. And it's principally around the relative risks and benefits of scoop and run versus stay and play. Now, I'll get to that in a second. But until about 10 years ago, it was general practice in roadside incidents and other major trauma centres, attending roadside accidents, to do as much as one could by the roadside, to have paramedics arrive at the scene and to overstabilise the patient before they were taken to a hospital to be treated by surgeons. And unfortunately, one of the lessons that we learned from the later Diana experience in '97 was that that's not always a good idea, and that there are certain circumstances in which nothing at the roadside can possibly save a patient's life, and that the risk has to be taken to scoop and run. Now, to use one of my favourite metaphors, and that would be the rugby ones, the forwards tend to determine who wins the game, but the backs determine what the score is. So the forwards can often fiddle around and play with the ball, pass it amongst themselves, often fumble and stumble, and if they're lucky, they may even inch it over the line. But unless they'll pass it to a back who can scoop and run with it, they'll likely, hopefully, win, but probably not by a big margin. And that seems to be the lesson from a lot of the experience in the past generation, that on the battlefield and at the roadside, it's usually wisest to pick up the patient, stabilise them as best one can, and then take them straight to a major. So as a clinical lead at King's, I helped negotiate King's contract as the major trauma centre. And additionally, I believe I was effective in embedding the role of rehabilitation medicine within the clinical care pathway. And I believe one of the successes in that process was to establish that a patient had to be assessed by a rehabilitation medicine consultant within 3 days of admission to a major trauma centre. That hasn't always proven to be possible, as some major trauma centres don't even have a rehab medicine consultant. But when the one is available, that's the expectation, that a rehab medicine consultant assesses these patients in the major trauma centre within 3 days of admission. Now, another little sidebar here is that Britain, unfortunately, doesn't have the same number of rehab medicine consultants per capita that other countries do. In fact, we're woefully behind European and North American countries, at the very, very bottom of the table. Nonetheless, there are in major trauma centres usually, if not rehab medicine consultants, then neurologists or orthopaedic surgeons who have sufficient skills to do a reasonably good job. One of the reasons that the rehab medicine prescription is so important is that in the absence of such a rehab medicine consultant, at least the rehab medicine prescription reminds people in the form of a checklist of the most important things to assess. Looking at the next slide, let's consider firstly what major trauma then is. And the simple phrase is it's a life-altering injury which risks death or usually serious disability. And it's not rare. We know that this is the major cause of death for people under 45. It's a very significant cause of long-term disability. And in the UK, more than half of major trauma is caused by road traffic accidents. That's typical, actually, of most developed nations. The US is an outlier because, of course, the US is a heavily armed civilian population who have a habit of shooting each other. But other than gunshot injuries in the UK and the US, that's also the case there, that road traffic accidents are a major contributor. There are a couple of things that have changed in the past few years, more in the developed nations rather than in the US, and that is that use of seatbelts and airbags has become standard, so that there are, even in very high impact injuries now, equipment to protect someone from some of the brain and spinal cord injuries that we used to see more of. Again, that's not always the case in the US because there appears to be a reluctance to wear seatbelts. As a sidebar, if you ever wondered why airbags have become universally fitted into all of our vehicles, it's because Americans don't wear seatbelts. Let's think then what a major trauma centre is. And in the slides that will follow, I'll cover some of the language used, trauma centres and trauma units and things. So a major trauma centre, key here is centre, is a hospital, typically, teaching hospital, which has a number of key components that you won't find most other places, and that would be consultant-led care in a number of areas: anaesthesia, orthopedics, and neurosurgery. There may be plastics and general surgery specialists as well as part of that major trauma centre team. They'll also have resources such as a CAT scanner. Most of them have MRIs nowadays. Some of them will have more than one CT scanner. And they'll have provision to triage a patient straight to an operating theatre. The ambulance crew will, of course, call ahead. The patient's being triaged to a major trauma centre because it's recognised at the roadside that the patient has suffered life-threatening injuries. And so bypassing other hospitals, the patient is brought straight to the major trauma centre where they are awaiting with radiology available and the operating theatre open and warmed up, and sometimes surgeons standing literally in their gowns waiting to save a person's life. Had that been the case in ~97, Princess Diana's ruptured pulmonary vein would have been fixed. She would likely have been brought to within to a hospital within about an hour. It took over 2.5 hours, and that life-saving surgery could have been performed had she been taken to a major trauma centre using this pathway. In the UK, the first ones opened in around 2012. Scotland was a little behind. And so here's a map on my next slide showing you where they all are. And you'd imagine then that from this map, most people in the UK would have quick and easy access to a major trauma centre. But unfortunately, there are a couple of regions on the extremities that aren't well served. North Norfolk, for example, or even Kent. And there's another issue regarding triage of patients from major trauma centres beyond. And I'll highlight, for example, spinal cord injury, whereby although there are a good selection of major trauma centres scattered around the country, there are far fewer specialist spinal cord injury centres. So if your major trauma centre patient has the misfortune to have suffered a serious spinal cord injury, they may not be triaged to a centre anywhere near their home. That's certainly the case for people in the southeast of England, that having come through the major trauma centre at King's College Hospital, they may subsequently be discharged for ongoing spinal cord rehab in Stoke or beyond. Moving on, the networks, centres and units are all terms that have particular meanings. So a network serves a defined population. So you can look at the network as being population defined. And it is intended to serve a population from the roadside to discharge back into the community and then ultimately community rehab. It's intended to be a pathway that rapidly sees a patient to the best place where they can be managed with the most appropriate care, and that ideally, being local as possible, the families are engaged as well. A network is expected to provide a comprehensive rehabilitation prescription. And within that prescription, the patient's pre-hospital history and their post-hospital phases of rehabilitation and recovery are expected to be considered. The rest of the questions around networks are based around whether the network has a properly functioning major trauma centre, which has negotiated healthy relationships with major trauma units, and whether the major trauma centre and the units have negotiated healthy relations with community rehab services. Beyond that, I'd add that the major trauma centre as an NHS facility, and the units and other community services, again, as NHS services, need also to nurture healthy relationships with the private sector as well, through, for example, interim payments. And if a case manager appointed privately is to be properly used, then again, those are relationships that have to be nurtured. And that's an active process whereby they have to actually be participating in the NHS major trauma rounds, ward rounds, and discharge planning. That's key then to a patient's migration from major trauma centre, part of the major trauma network, into the units, which may be more local, once they become medically stable. So just to recap then on what a major trauma centre is offering, it's as part of a major trauma network, it's a specialist centre, a unit which has essentially all the resources that one would expect at some of the most sophisticated hospitals in the world, for patients to be treated immediately, triaged there 24/7, and to benefit from medical and surgical care that will then lead them to become stabilised and suitable for discharge, either to a less intensive hospital environment or back to the community, under the guidance of a rehabilitation medicine consultant who will have seen that person within 3 days. So where will they go then? Having become stable at the unit, the patient then may be transferred home, or they may be discharged to a major trauma centre, which is a facility closer to the patient's home typically, providing 24/7 medical and surgical cover, but not necessarily at the intensity that they enjoyed at the major trauma centre. So I'll just touch upon this on the next slide. So as I've suggested, the patient may also go home. And here's someone who has become stable in their major trauma centre, and discharge planning has been arranged on the basis of that rehab prescription. They have potentially need for follow-up in surgery or medicine, but that'll again be highlighted in the rehab prescription. So let's look at why these major trauma centres and networks were set up, because it was at some cost and at some great inconvenience. Well, firstly, we'll recognise that this is not a small need. As my earlier slide indicated, even when this need is properly met, major trauma is still a cause of the majority of death and illness in a number of patient categories. I'd add, though, to that slide that there are still a couple of unmet needs in that major trauma centres generally don't serve paediatric patients particularly well. And there's a second cohort of patients who are older, who may not do as well in a major trauma centre as one would hope. So whilst the majority of patients who come through major trauma centres are adults, and there is a preponderance of relatively young male adults, because young male adults do stupid things on Saturday nights involving cars and alcohol, there are two other peaks, and that would be children and the elderly. And as I said, those two other peaks aren't as well considered as the otherwise pre-injury healthy young adults. Patient outcomes were known to be worse in the UK for these patients having suffered a major trauma when comparisons were made with outcomes in other Western economies. In 2010, audits revealed that we were delivering poor outcomes when it came to mortality and morbidity, and questions were raised as to why that was. It was recognised that there was insufficient clinical cover and that those clinicians who were available weren't available all the time. Staff were struggling to maintain their expert skill levels in some centres because they simply weren't seeing enough patients, whereas other staff were struggling to maintain their own health because they were overworked. It was recognised that there was a need to transfer people then to specialist centres, and that delaying transfer to a specialist centre was sometimes itself a cause of mortality. So this is again back to my recurrent theme of the contrast between the benefits of stay and play versus scoop and run. And I recognise this isn't a black and white choice. I mean, there's clearly a compromise to be reached, but the delay in bringing Diana even to the A&E of 110 minutes, and then the subsequent delay in treating her because, frankly, they weren't ready for her and haven't made a decision yet. So it illustrates that there simply is nothing to be gained for many patients in trying to fix things by the roadside. So let's look at how the major trauma centres and the networks within which they operate, how they function. So there's a patient who has been severely injured at the roadside and they're assessed by the ambulance staff at the scene. The ambulance staff will then wisely, would hope, recognise the severity of their injuries and triage them straight to the major trauma centre if it's safe to do so and if the patient doesn't need further stabilisation. And therein lies the rub, because of course it could always be argued that the patient would be a little bit safer if we only stayed a bit longer and stabilised them just a little bit more. But of course that's a balance to be struck, isn't it? Because delay costs lives, and yet firm decisions have to be made. Nonetheless, patients are triaged straight to the major trauma centre appropriately. They're cared for at the major trauma centre by experts following appropriate diagnosis, etc. And they've always, of course, been nowadays warned ahead of time by the ambulance crew. Of course, ambulance crews having much better communication with the major trauma centres is another positive factor. They may need to be taken just to a trauma unit if they are so unstable that the drive that extra half a mile to the major trauma centre would likely result in death. That's unusual, however. So generally, the most severe patients are taken to the major trauma centre urgently, flashing red and blue lights, bypassing other hospitals. If they're at risk of dying imminently, then to the major trauma unit. And also less severe injuries will be taken to the nearest trauma unit. Some patients are recognised not to really need to be triaged to a major trauma centre at all. Of course, the majority of injuries at the roadside are not so severe that patients have to go to anywhere within the major trauma network. Each major trauma centre will see several patients a day, which addresses the concern that was raised in the audit that some centres have clinicians who just don't have enough practice in keeping people alive. So it was anticipated that there would be some real benefits to major trauma centres. Well, certainly we were underperforming, so the goal was to do better. And it was anticipated that between 400 and 600 patients' lives might be saved per year. The reason, of course, was that providing 24/7 emergency care in this way would provide each patient with a more appropriate care. Long-term disability was expected to improve, and specialist care and specialist rehab was expected to be applied sooner. The benefits, of course, societally would be that patients would ultimately be less disabled, more able to return to work, therefore pay their taxes and have a higher quality of life. The simple measure, of course, is whether the patient lives or dies. And it was anticipated that about 15 to 20% fewer people would die. We now have about 10 years of evidence to see whether those optimistic predictions have been borne out. And the news is good. It shows that we have made full use of major trauma centres, and that the major trauma centres themselves are what we had hoped for diagnostically and in terms of clinical treatment. We know then that having used major trauma centres and established them properly, there has been a reduction in death. Now, these numbers are pretty convincing, I believe, that the differences are of the orders of about 9% across the country, for example. But we need to be a little cautious here, because these are not randomized controlled trials. This is not a double-blinded, high-quality trial that we're reporting. This is just observational studies. Nonetheless, I believe that the trends are quite clear. There's been a trend towards greater survival, and there's generally been a trend towards reduced disability. And one of the reasons I believe that we can conclude that there's reduced disability is because patients are more likely to be triaged to the appropriate rehabilitation services. And this is principally on the back of the rehabilitation prescription. Now, next couple of slides, I'm going to just cover a couple of little obstacles here to understanding what the rehabilitation prescription consists of, because there are just a few designations within the rehab prescription that are confusing. Anyway, it's used to triage a patient to the right level of rehabilitation. There's no particular template for a rehab prescription. So you might be surprised to learn that each CCG, each major trauma network, which owns its regional, is owned by its CCG, has come up with its own form. So the rehab prescription in Manchester will look different from that in Liverpool. But the content is essentially the same. And it's recognised that even were a patient to be triaged into the major trauma network, either to a unit or to a centre, most patients don't require more than a relatively light inpatient rehabilitation programme, if any. But even if that's the case, if only a level 3 facility is required, that needs to be made clear on the rehab prescription. So the specialist area here is when the patient requires level 1 or 2 rehab. Now, rehab level 1, rehab level 2A and 2B, or rehab level 3 are designations of service providers. These describe the complexity of rehab provided at a given institution. So Norfolk Park, for example, would be level 1. This is a unit designed for patients who have very complex needs, possibly intubated. A level 2A, all of the above, but not intubated patients. Level 2B would be patients who have less needs, maybe only 2 or 3 therapies, and people who maybe appear to be the walking wounded. And similarly, a level 3 unit would no longer have to be run by a rehab medicine consultant, whereas levels 1 and 2 must be. And a level 3 unit would provide a fairly light touch of rehab, and the patient would be expected essentially to get along with rehab assistants and their family members before having had a brief discharge going home. Okay, that's fairly straightforward, isn't it? Because that describes levels according to levels 1, 2A, 2B, and 3, as you see on that slide. Okay, but the rehab complexity scale extended, the RCS-E, which is also on this slide, also uses numbers of 0 to 4. And that's about the patient, not about the facility. So confusingly, the rehab prescription might have on it that the patient has an RCS-E score of 2 and therefore requires a level 2A rehab unit. Okay, a level 4 might require a level 1 rehab unit. So you can see that the numbers are in reverse order. The more complex a patient is, the more likely they are to score 3 or 4, whereas the more complex the provision of the service is within a unit, the more likely that unit is to be level 1 or 2A. I hope that's clear, but it is sometimes even confusing to many clinicians with whom I've worked. It's a very poor way of doing things. Okay, so here's a graphic of how things should progress. From the roadside immediate care, having suffered a severe injury, through acute care in the major trauma centre or possibly unit, into rehab, which may be, in this case, a level 3. And then from there on to outpatient services, and then into the community with integrated care planning. And at any point along this, a patient may be moved either up or down that pathway, and at any point after 72 hours is a bit late, but at any point a rehab medicine consultant can be asked to participate in planning ongoing therapies, liaising with community services, communicating with other doctors, other consultants, and then ultimately seeing that the patient's discharged to the community with the best care and therapies they require. Okay, so I hope that's covered the major trauma centre unit and its purpose, the rehab prescription and its purpose. And more generally, I hope I've left you with a sense as to the value of having instituted this change in the past 10 or so years, that it has now objectively been measured. It has resulted in fewer deaths. Ultimately, it's resulted in more people getting back to a high quality of life. And that at any point along this pathway, a rehab medicine consultant can and should be involved in the planning. Sometimes, of course, those rehab medicine consultants are brought in, as I am sometimes, as a private consultant. And again, the communication between the private NHS consultants is important as well. So this is key, good communication. And finally, I'll give you the thought that in all of my medical legal practice, and I've done a lot of it, it's basically what I do nearly all the time now, the common theme in practically all of the cases that I've dealt with, it has not been poor care and it's not been medical mistakes. Generally, it's poor communication. That the team members in what is certainly by definition in rehabilitation medicine, a team approach, it stands or falls on good communication between all the participants from the very beginning during the assessment, even at the roadside, until a patient is trying to get back to work, trying to get back on their feet in the community. Every step along the way, communication has always been the most important feature of a successful outcome. So thank you. I think I'm done here, and I'm going to pass the baton back to Paul.
Thank you very much, Julian. Just to say that obviously this session has been recorded today. So if you have any questions regards to the content of today's presentation, if you want to either email me, you can telephone me, or any questions can be lodged on Twitter. My Twitter handle's just referenced there. And thank you again for Remote Rehab for giving us this platform today just to present. And so hopefully you found it helpful. Many thanks.